I've seen a lot in 30 years. Family court in Manhattan will cure you of any romantic notions about human nature fast. But every now and then a case walks through that door that makes even me sit up a little straighter. This was one of those cases. A single mother, a $5,000 fine, and a story that had half the courtroom ready to cry and the other half ready to applaud, and I hadn't even asked my first question yet. If you believe the truth matters more than a good sob story, hit that like button right now, because today we are going to find out which one we're dealing with. Stay with me. I promise you won't want to leave before the ending. Her name was Darlene Morrow, 34 years old, 2 kids, ages 7 and 9. She walked into my courtroom in clean, pressed clothes that had clearly been ironed that morning. I notice things like that. When someone takes the time to press their clothes before facing a judge, it tells me they understand what respect looks like. It doesn't tell me they're innocent, but it tells me something. The plaintiff, the person bringing the case, was her former landlord, Gerald Whitmore, mid-60s, 3-piece suit that cost more than most people's monthly rent. He sat at that table with the kind of settled confidence that comes from having sued people before. He wasn't nervous. He was comfortable. And that told me something too. Subscribe to this channel if you want to see more cases from my courtroom, because this one is going to test everything you think you know about right and wrong. Gerald Whitmore was suing Darlene Morrow for $5,000 in property damage. He claimed she left his rental property, a 2-bedroom apartment in a decent part of town, in a state of complete destruction. Holes in the walls, carpet destroyed, broken fixtures. He had photos. He had estimates from contractors. He had a very organized folder that his attorney had clearly spent time preparing, and he presented all of this with the calm confidence of a man who expected to win before I spoke a single word. I've seen that confidence before. Sometimes it's earned, sometimes it's a performance. I looked at his photos first. That's always where I start, the physical evidence, not the feelings. The photos showed damage, no question, scraped paint, a bathroom fixture hanging off the wall, a section of carpet near the kitchen doorway that looked like something had been dragged repeatedly across it. Real damage. I'm not dismissing that. Property damage is real. It costs real money, and landlords have real rights. But here's the thing I've learned from decades on the bench. The question is never just whether damage exists. The question is who caused it, when, and under what circumstances. Because those 3 things change everything. So I looked up from those photos, and I looked at Darlene Morrow, and I asked her one simple question. Did you cause this damage? She didn't flinch. She didn't look at the ceiling. She didn't do that thing people do where they take a long breath to buy themselves time to construct an answer. She looked directly at me, and she said, "Some of it, Your Honor, not all of it." I raised an eyebrow. Now we're getting somewhere. Hit that like button if you're already sensing this is more complicated than it looks, because it absolutely is. Some of it, I repeated. I like to repeat things back. It gives the person a chance to hear what they just said and either commit to it or backtrack. Darlene Morrow didn't backtrack. She nodded and said, "Yes, ma'am, some of it." Gerald Whitmore shifted in his seat, just slightly, but I caught it. I turned to him. "Mr. Whitmore, when did Ms. Morrow move into this property?" "March of 2021. "And when did she vacate?" "September of last year." "So approximately 2.5 years?" "Yes." "And during those 2.5 years, how many maintenance requests did Ms. Morrow submit to you?" He paused, just long enough. "A few." I looked at my clerk, Margaret. She's been with me for 11 years. She didn't say a word, but I saw her mouth tighten just slightly. We both caught the same thing. A few is not a number. A few is what you say when the real number is inconvenient. I turned to Darlene. "How many maintenance requests did you submit, Ms. Morrow?" She reached into a folder, her own folder, not nearly as polished as his, a manila envelope that looked like it had been sitting in a kitchen drawer, and she pulled out a stack of papers. 17, Your Honor." The courtroom got very quiet. Before I tell you what I found in those 17 requests, because what I found changed this entire case, I need you to share this video with someone who needs to hear it. Share it right now. Because this is the part where most people stop watching, and you do not want to stop watching. 17 maintenance requests over 2.5 years. I started reading, not skimming, reading, because documents don't lie. People lie. Documents just sit there telling the truth until someone finally pays attention to them. The first few requests were minor, a dripping faucet, a cabinet hinge, Normal stuff. But then I started seeing a pattern. Request number 4, bathroom fixture loose, reported 18 months before she moved out. Request number 7, water damage near the kitchen doorway, reported 14 months before she moved out. Request number 11, hallway carpet buckling due to moisture underneath, reported 11 months before she moved out. I looked up at Gerald Whitmore. Mr. Whitmore, do you dispute that these requests were submitted? I addressed them as they came up. That is not what I asked you. I set the papers down flat on my desk, which is something I do when I want someone to understand I am done with vague answers. Do you dispute that these requests were submitted? He adjusted his tie. No. Thank you. Now we're getting somewhere. I turned back to the documents. The bathroom fixture that was loose 18 months before move-out. That same fixture appeared in his damage photos. The carpet buckling due to moisture underneath? That was the carpet near the kitchen doorway in his photos. The scraping pattern wasn't from dragging furniture. It was from the carpet lifting and catching on shoes over a year of unaddressed moisture damage. This is where I want to be clear about something. I'm not a pushover. I'm not here to protect tenants at the expense of landlords. I believe in property rights. I believe in contracts. I believe that if you damage something that isn't yours, you pay for it. That is non-negotiable in my courtroom. But I also believe that a landlord who sits on 17 maintenance requests for 2.5 years and then photographs the resulting damage as tenant destruction is not a victim. He is an opportunist, and I was about to tell him exactly that. If you believe landlords and tenants both have responsibilities, leave a comment below. Tell me, at what point does neglect become damage? Because that question was sitting right in the middle of this case. Now here's where it gets more complicated, because Darlene Morrow didn't get off clean. I told you she said some of it, and I told you I intended to find out which part was hers. There were 3 items in Whitmore's damage claim that did not correspond to any maintenance request. A hole in the drywall in the second bedroom, approximately the size of a fist. A broken kitchen cabinet door, not the hinge, the door itself, which had been pulled hard enough to crack the frame. And a cracked bathroom mirror. I asked Darlene about those 3 things specifically. I looked her straight in the eye and I said, these 3 items, the wall, the cabinet, the mirror, I don't see them in your maintenance requests. Did you cause this damage? This is where people usually look away, start explaining, start talking about how hard their life was and why none of it was really their fault. I've heard every version of that story. I have no patience for it. Darlene Morrow looked me straight back and said, yes, Your Honor. The room shifted. You could feel it. My bailiff, Frank, 22 years working courtrooms, seen everything twice. I caught him looking at me with that look, the one that means even he didn't see that coming. Yes, I repeated. Tell me what happened. She explained, without drama and without excuses, that there had been a period, about 8 months before her lease ended, when her older child's father came back into the picture. There had been a difficult situation. She described it briefly, carefully, and without turning it into a performance. The wall, the cabinet, the mirror. She wasn't claiming accident. She wasn't blaming anyone else. She said, I should have reported it, and I didn't. I was embarrassed and I was scared and I should have handled it better. I sat with that for a moment. In 30 years on the bench, I have had people lie to me with tears streaming down their faces. I have had people tell the truth with no emotion at all, just flat, clear fact. Darlene Morrow told the truth the way people tell it when it costs them something. That is the only kind of truth I trust. Subscribe to this channel if you believe accountability matters, because what I was about to decide was going to require every bit of it. Now I had the full picture, and let me tell you what I saw. I saw a landlord with $5,000 in claims, approximately $3,200 of which traced directly to damages that his own negligence had allowed to worsen over 2+ years of unaddressed maintenance requests. I saw a tenant who had dutifully documented those requests, who had taken her responsibilities seriously enough to keep paper records when most people wouldn't bother, and who had also, let me be absolutely clear, caused real physical damage to 3 specific items that she had no right to damage. Gerald Whitmore wanted full payment. He wanted $5,000, and he wanted Darlene Morrow to sit in that chair and be made an example. But here's what he forgot. In my courtroom, the example cuts both ways. I asked him point blank, Mr. Whitmore, did you ever respond in writing to maintenance request number 11, the moisture damage to the kitchen carpet? I sent someone out. Did you document it? Pause. I don't think I have that specific record. So your answer is no. I may have verbal no. Your answer is no. You don't have documentation. I leaned forward. Mr. Whitmore, you came into this courtroom with a very organized folder. You have photos, estimates, a timeline of damages. You are a detail-oriented man. So I want you to explain to me why, if you responded to a written maintenance request, you have no written response. He didn't have an answer for that. The courtroom was very still. This is where cases turn, not on the big dramatic moments, on the small specific detail that doesn't match the story. If it doesn't make sense, it's not true, and this didn't make sense. Before I tell you exactly how I ruled, share this video right now, because this ruling is going to surprise you, and it's going to make you think. Here is what I decided. I awarded Gerald Whitmore $100. That $100 represented the fair repair cost of the 3 items Darlene Morrow admitted to damaging: the drywall, the cabinet door, and the mirror, calculated at contractor rates, not inflated emergency quotes. I used the estimates in his own folder to calculate it, stripping out the items that corresponded to his neglected maintenance requests. The remaining $3,900 of his claim, denied, because when you have 17 written maintenance requests and you ignore them for months and years and the result is water-damaged carpet, a failing bathroom fixture, and paint deterioration, that is not tenant destruction. That is landlord negligence. You do not get to let your property deteriorate through inaction and then hand a single mother the bill. Gerald Whitmore did not like this ruling. He started to speak, and I held up one hand. I'm speaking. He stopped. I looked at him and I said this, and I want you to hear me clearly. You came in here today looking for a payday. What you're leaving with is a lesson. You own property. That is a privilege and a responsibility. Your tenant followed the rules. She submitted requests in writing. She documented everything. She did her part. You did not do yours. And when you fail to maintain what you own, you don't get to profit from the consequences of your own neglect. He had nothing to say. Then I turned to Darlene Morrow, and this is the part that left that courtroom quiet, because she had won, mostly, but she hadn't escaped accountability, and I wasn't going to let her. I looked at her and I said, Ms. Morrow, you impressed me today. Not because you walked in here with pressed clothes and a neat folder, because you told the truth when it cost you money to tell it. In 30 years on this bench, I have seen very few people do what you did. You looked me in the eye and you owned your piece of this. That matters. That is not nothing. She nodded. Her eyes were steady. But I want you to understand something, I continued. You owe $100 and you are going to pay it. Not because I don't understand what you've been through. I understand exactly what you've been through. But your children are watching how you handle the things that are hard, how you pay a debt you owe, even when the person you owe it to isn't a good person. That $100 isn't just a judgment. It's a lesson for those 2 kids about what integrity looks like. The courtroom was completely silent. Frank, my bailiff, was looking straight ahead the way he does when something lands. Margaret had her pen set down on the desk. Even Whitmore's attorney had stopped writing. If this moved you, if you believe that accountability and empathy can exist in the same ruling, leave a comment below and tell me what you thought. I read them, every single one. That was months ago now. I've thought about that case more than I expected to. I received a letter, and this happens sometimes. People write to the show, a few months after the ruling. It was from Darlene Morrow, short, 2 paragraphs. She told me she had arranged a payment plan and made the final payment on her $100 judgment within 90 days. She said her kids knew why she was making those payments. She said her 9-year-old asked her once why she had to pay money to someone who wasn't even nice, and she told him, because we don't do things because other people deserve it. We do things because we do. I read that line twice. That right there. We don't do things because other people deserve it. We do things because we do. Is a 9-year-old learning something that some adults never figure out. That is a mother doing her job even when everything is hard and nobody is applauding. Gerald Whitmore filed no further action. I didn't expect him to. Here's what this case taught me, or rather, what it reminded me. I already knew it. 30 years of family court burned it into me, but it's worth saying out loud. The courtroom is not a place where good people always win and bad people always lose. Life doesn't work that way, and neither does law. What the courtroom is supposed to be is a place where the truth finally gets heard, where the paper trail gets examined, where the story that's been running in somebody's head without challenge finally meets the version of events that actually happened. In that courtroom, 2 people told 2 very different stories. One of them had a nicer folder. One of them had the truth. I know which one I respected when I walked out that door. Do not reward excuses. Do not punish honesty. And never, not ever, let someone hand you the bill for their own neglect. If you believe that people should be held accountable, all people, landlords and tenants, the powerful and the struggling, share this video right now, because these stories need to be told, and they need to be told honestly, not just the ones that make you feel good. And one more thing before you go. Subscribe to this channel if you want to see more cases from this courtroom, because I am just getting started. Every case that comes through that door teaches something. Some of them teach loudly and some of them teach quietly, but they all teach. Darlene Morrow walked out of my courtroom owing $100 and carrying her dignity. Gerald Whitmore walked out with $100 coming to him and nothing else. The math was simple. The justice was not. And that is exactly how it should be. Tell me in the comments, what would you have ruled? Would you have gone harder on her? Lighter? Would you have thrown his entire claim out? I want to know what you think, because justice is a conversation, and this conversation is not over. But I'll tell you this much. Nothing, and I mean nothing, prepared me for what walked into my courtroom the very next week.